Hello, everybody. This is the beginning of section 2 from chapter 13. We are going to be talking about the Fourth Amendment, and more specifically, your right to be secure. So, understanding search and seizure. So, according to your textbook, and as written in the Constitution, the right of the people to be secure in their persons, homes, papers, and effects against unreasonable search and seizure shall not be violated. So, as you remember from past discussions, we went over several terms. Today, we're going to look at Supreme Court cases that have helped to kind of identify some of your freedoms and what ways your freedoms can be legally limited. All right? So, understanding searches and seizures. A search is any action by government to find evidence of criminal activity. That is the answer to question number 6 on your exam. On your quiz. There is going to be 1, 2, 3, 4, 5 questions, and it is actually going to be matching. So the letter for number 6 is the letter I, as in ice cream, okay? I. So a seizure, okay, which is the answer to number 7, letter J, okay, occurs when authorities keep something. So it's an object or a person kept by government as a result of a search. So the government can take, drugs that they find or other evidence to a crime. It can also include you, not just an object, but a person. If you're arrested, that is a seizure. Not all seizures involve arrests, but all arrests are a seizure. Okay? So let's continue. What's really important to understand is the difference between an unreasonable search and a warrantless search, okay? This is really important to understand. So the Fourth Amendment states that no warrant shall issue but upon probable cause. Okay, so this is really important. In order to obtain a warrant, a court, which is a court order to search for something or to seize someone, right, like an arrest warrant, there must be probable cause or good reason to believe that the search will produce evidence of a crime or that the person who is arrested did in fact commit the crime. Okay. So many Supreme Court cases have held that warrants are not always necessary. However, whether a warrant is required or not, probable cause is usually needed in order to make a search. Okay, probable cause is always needed to make an arrest. Okay, so in general, a search warrant is needed to look inside of something, right? To look inside your home, to look inside the car. The warrant must state what is being searched and what authorities are looking for. So if somebody comes, knocks on your door, says, "We are the police, we're here to arrest Josh," right? You would have to say, "Can I see the warrant?" Right? If it doesn't have the location on it, if it doesn't have Josh's name on it, it is not okay, right? There are many instances in which a search warrant is not required, and this is really important. Plain view doctrine, okay? If an object is in plain view, the law assumes that the owner does not consider it private. Plain view doctrine, letter G, is the answer to question number 8 on your quiz. Okay? So let's continue. No matter where a person is, he or she has no expectation of privacy when it comes to the possession of illegal drugs. So this is something that's important to understand. There are times when searches do not need warrants. And let's go ahead and read right here. According to the Supreme Court, no search warrant is necessary in some emergency situations or when protecting the safety of the police or the public. Right? So if you give consent to a search, the police do not need a warrant. Okay? Police can conduct a search limited to the person placed under arrest and in the area immediately nearby. right? So if you were doing something terribly illegal, right, terribly illegal, and you are arrested, it makes logical sense under this lawful arrest that the police can look immediately around you to see, were you carrying any weapons? Are you in possession of any drugs, right? Giving a pat down, for example, checking for guns or knives. And it's in the interest of the safety of the police officers. If the police are chasing a suspect, they can follow this person into a building and seize any evidence they find. So let's say Kellen stabbed okay, we'll just go for it, okay? Kellen stabs Corbin in the neck, and it's super illegal, and it's totally appropriate for the police to arrest Kellen, and Kellen decides to make a run for it, okay? The police can chase Kellen, and if Kellen runs and runs and runs and runs into my house, the police can follow Kellen into my house, and if they capture Kellen and they notice that, 10 feet away, kind of underneath a table, there's a bloody knife, it is then appropriate for them to seize this evidence, right? Because it happened in hot pursuit. I'm sorry, Kellen. I'm sorry, Corbin. I know you two are friends. Anyway, I really need to start using fake names. All right, emergency circumstances. So let's say that there is a building with a bomb threat. Police do not need a warrant to enter this building, okay? Or if they heard shots fired, they do not need a warrant. That would be crazy, right? If there's shots fired in McDonald's, you can assume there could be some casualties. It would not make sense for the police to then have to get a search warrant before they can enter, like the private office locked up in the back. Like, they can kick down the door, do what they need to do to make sure everybody's okay, to deal with the bomb threat, to deal with an active shooter, etc. Automobile searches. In general, police do not need a warrant to search a car or anything inside of it. However, they still have to have probable cause to suspect that the car holds evidence of a crime. So police cannot just walk up to any old person and be like, hey, let me see inside of your car, right? But if a person's driving erratically, you might be able to reasonably assume that they're under the influence of something. If there's probable cause to pull this person over, it would make sense then to peek inside the car. Is there an open alcohol beverage container? Is there, drugs on the seat, etc.? So in Katz v. United States, it was decided that the Fourth Amendment protects people and not just places, right? Wherever a person is, his or her right to privacy is protected if he or she has exhibited a reasonable expectation of privacy. So the level of privacy depends in part on where a person is, right? So if you're in a coffee shop or you're in your home, there's a greater expectation of privacy in a person's private home than in a public place. Alrighty, let's continue. I'm sorry, guys. I'll go ahead and skip this. All right. So the Fourth Amendment provides that people will be secure in persons from unreasonable search and seizure. All right. So in general, police do not have the right to stop people randomly on the street and search them. So this is known as stop and frisk. So in Terry v. Ohio, let's see. In Terry v. Ohio, the court ruled that police could stop people who seemed to be acting suspiciously and pat them down for weapons. So a warrant or probable cause is not needed for what is called a Terry stop. Okay, a Terry stop. Because the public safety outweighs this person's right to privacy. So intrusive searches, if you're following along, I'm now on page 408, okay? So 3 questions are considered in deciding whether such a search is reasonable under the Fourth Amendment, okay, when it comes to searching a person's body. So what is the legal status of the person being searched? For example, if a person is in police custody or suspected of a crime, that's going to be a lot different than if it's just, Sally Sue standing on the corner buying an ice cream cone. How invasive is the search? Does it involve intrusions beyond the body's surface? So if you've just been arrested, having a pat down, looking and checking your pockets, looking for drugs or weapons, that's going to be a lot different than if a person is arrested and being put into prison and having a strip search, right? It's really, really critical that a person does not bring drugs or weapons into a prison, so a higher level of search would be appropriate in this case. And does the search involve or serve some safety or security need for society? This is known as the special needs test, okay? The special needs test, which is question number 9 on your quiz. The answer is the letter K. It's a standard used by the Supreme Court to determine whether a search of a person's body meets a security or safety concern of society and is therefore reasonable under the Fourth Amendment. So drug testing. Drug tests are also considered to be intrusive searches because they require blood or urine samples. And in most cases, they require a warrant or at the very least, probable cause. All right. The court has removed requirement for certain groups of people. For example, let's say you work in a position where you are driving semi-trucks, right? It is very important to public safety that you not routinely use drugs. You should not be driving under the influence. And so private businesses are allowed to randomly drug test employees. Additionally, this has been expanded when it comes to students. The court has expanded the special needs test to public schools. Okay, schools may require random drug testing of athletes, even if no one is suspected of drug use, because they feel that it is in society's best interest to deter drug use of the nation's school children, right? So let us continue on and discuss students' Fourth Amendment rights, okay? So in general, the courts limit students' rights as opposed to the average population. So the reasoning is the same as limiting students' First Amendment rights. And if it's in the best interest of the rest of the student population, okay, then it makes sense, it is reasonable to limit these rights. So students' rights may be restricted in order to preserve learning environments, safety, etc. An example of this case, a great Supreme Court case that we're going to discuss is New Jersey versus TLO. Okay, New Jersey versus TLO. The court ruled that probable cause is not needed for school officials to search students as long as the circumstances make the search reasonable. Okay, so there's an example where, or not an example, in this case, a teacher found a girl smoking in the bathroom. And so the teacher brought the student to the principal and said, hey, I found Sally, this isn't her actual name, I'm making one up. I found Sally Sue smoking in the bathroom. The principal asked the student, hey, were you smoking? The student said, no, I was not. Completely denied it. So the principal said, all right, I have, probable, reasonable suspicion that you were smoking. A teacher saw you. I'm going to search your person and your backpack. They searched, and not only did they find cigarettes on the student, but they found marijuana. Okay, so the court ruled that the principal's search of the purse was not unreasonable. There was a reasonable, a probable cause to search the student's possessions. There was a good reason to search, and so by finding this stuff, it was not done so illegally. So after this ruling, most cases involving student searches were decided at the state level. For example, it's been decided that lockers are school property and students have no expectation of privacy. Let's continue on. Again, Because we don't have the interactive component of these discussions like we do in the classroom, feel free to start a discussion on the video link in Google Classroom. Talk about it with your classmates back and forth. If there's something you don't understand or you want clarification on, start a conversation. And students, if you see that a classmate has asked a question, you don't have to wait for me to answer. You guys can continue to talk about this amongst each other, okay? So in 1967 in Catesby, United States, the Supreme Court made a decision on wiretapping and other forms of electronic surveillance. This is what is known as cyber surveillance, which is searches of wireless communications. Okay, so cases involving cyber surveillance have yet to reach the Supreme Court, and I think this is a very reasonable, it's reasonable to believe that this is the future of the Fourth Amendment decisions made in the at the Supreme Court level. So quiz question number 10, the answer is A, cyber surveillance. Searches of wireless communications is A, cyber surveillance, all right? Let's continue on. The Fourth Amendment since 9/11 has been treated a little bit differently. So in 2001, Congress passed the USA Patriot Act, which greatly relaxed privacy protections and controls on searches and seizures. What upsets people the most, especially civil liberties advocates, is some of these searches do not require a warrant and instead are authorized by a national security letter. And unlike warrants, these are not issued by a judge, and probable cause is not needed to obtain them. Okay, they're signed, issued, and used by the FBI and other government agencies, and the recipient of an NSL is prohibited from disclosing that the letter was ever issued to them in the first place. So this really upsets a lot of individuals, and you can imagine, because it's so hush-hush, it's left to your imagination what that includes, right? So several Fourth Amendment challenges to government surveillance programs are now before the courts. Again, this book was written in 2012, so it's interesting to see changes between 2012 and now. If you guys put any effort into looking this up and sharing it with the class, I will be happy to give you extra credit. I think that is a really good use of your time. All right. So in the United States v. Arnold, a federal court ruled that authorities violated Arnold's Fourth Amendment rights when they searched the contents of his laptop as he went through airport security. All right, authorities argue that the search was routine and it didn't require reasonable suspicion, and the courts ruled that this was inadmissible. All right, so the government has appealed the ruling. So remember that the TSA works for or is a branch of the government. In 2006, the Electronic Frontier Foundation, a communications watchdog group, filed a class action lawsuit in federal court against AT&T because they would turn over phone records of millions of Americans to the NSA. And so this was upsetting to a lot of people, hence the class action lawsuit. And the government argues that some actions are necessary in order to protect national security. So this raises the question, okay? And I'm not looking for you to answer it, but I want you to think about this. At what point, okay, is it worth giving up some of your personal freedoms in the interest of security? Where is that line drawn for you? I think the future of the Fourth Amendment basically comes down to this. How many personal freedoms are we willing to give up in favor of national security? Where is the balance between these two? That's the end of our lecture today. Thank you for listening. And I actually don't look forward to making the next one. I'm sure y'all don't look forward to hearing it, but I'll see you in section 3.